Every business, regardless of its size, must provide its employees with safe working conditions. And considering the range of potential hazards, from asbestos to slippery stairs to excessive noise, that can be difficult for a small business. And why should everyone be so concerned about job safety and health? Because each year, approximately 6,000 employees in this country die from workplace injuries, while another 50,000 die from illnesses caused by exposure to workplace hazards. In addition, 6 million workers suffer non-fatal workplace injuries at an annual cost to U.S. businesses of more than $125 billion. Standards and rules for safe working conditions, tools, equipment, facilities, and processes are set by the Labor Department's Occupational Safety and Health Administration, OSHA. OSHA standards apply to every private employer with one or more employees, except for those in industries covered by other federal job safety legislation. Today, roughly 93 million employees across the country are protected by state and federal OSHA programs. But even with adequate safety measures, accidents do happen. In this Insider exclusive network TV special, we visit with Andy Siegel and Siegel Coonerty, partners at the Siegel Coonerty Law Firm, to learn how they successfully represented their client in a construction accident case that resulted in a record settlement of $7.5 million. They both have earned reputations as unyielding trial lawyers who repeatedly represent individuals and families against big companies and the Goliaths of the world, and repeatedly win. They have earned the highest respect from citizens and lawyers alike as one of the best labor law and traumatic brain injury law firms in New York. They've built a substantial reputation by consistently winning cases other law firms have turned down, and their amazing courtroom skills and headline-grabbing success rate continue to provide their clients with the results they need and the results they deserve. This is the Insider Exclusive, live from New York. It is my great pleasure to introduce Siegel Coonerty and Andy Siegel to the show. Welcome to the show, guys.
Thank you.
Andy, tell our audience exactly what type of law your law firm practices.
We have a particular focus on representing survivors of traumatic brain injury. However, we have a diverse practice where we represent people with injuries that are other than the brain.
And I understand that your specialty, Sean, is labor law, isn't it?
That's correct. In the sense of construction accidents that cause a construction worker to have a severe injury.
Yeah, here in this city, and you represent people all over the state, I would imagine, right? But here in this city, there's a lot of accidents, right?
There are.
Everywhere we look, when we were driving here, we saw buildings under construction, and it's amazing. Do you ever represent passerbys that get injured by things that are falling from buildings?
As a matter of fact, we have, and there is actually a specific section within not the labor law, but one of the codes that the labor law is based on, the industrial code for the state of New York, that actually speaks about that actual incident occurring. And we have had that, but it's infrequent. More often, we've had a construction worker that potentially was not involved in that aspect of the construction, but just happened to be walking to their truck or something of that nature. One of which we had, this gentleman was just walking to his truck and the sidewalk shed collapsed and fell down on him like an accordion.
In this case, Sean, the story of Kenny O, tell our audience exactly what happened to Kenny.
Kenny was a roofer with a lot of experience, decades. And he was involved in the construction of a commercial building on Long Island. And when his accident happened, it was near the very end of the construction. He was up on a ladder. The ladder failed, meaning that the ladder slipped and fell sideways going across the building, causing him to fall 25 feet to the sidewalk below.
And he landed on his head, correct?
That's correct. He landed face first.
And this is one of those cases where, because somebody's severely injured, it's hard for them to remember exactly what happened, correct?
That's correct. It's even, with his case, it was even more so.
Yeah. Now, you obviously, as all good trial lawyers, put on your Perry Mason investigative hat. And what did you have to do to find out exactly what happened to him?
This case was unusual, not for our firm, but in the industry in general, because of the amnesia aspect of it. The fact that Kenny was never going to truly be able to tell us what happened. As a matter of fact, when I showed him photographs of the scene, he just stared at them, and I think he would have looked at them for hours. And what happened in this case is we had to reinvestigate all of it on our own because of the way it was being defended, them saying that it was Kenny's fault this accident happened. He didn't tie off his ladder. He should have never been on the ladder to begin with. He was only supposed to be working on the floor, doing small work where he never would have had to use a ladder. And what happened was this. We found out over time that certain people that were no longer working for the general contractor, we could then speak to because they were no longer employed. Anyone could talk to them at that point. And that's when we learned the work they were doing was actually corrective work, where they had to fix bad work that was done. And in order to do so, he had to be up on that ladder. And they were doing these punch list items at that time.
Right. How should the work have been done? Because you discovered that.
The work should have been done the way it was done originally, and that's with a scissor lift. Not on a ladder, but a scissor lift, which is enclosed and can raise up and down, move left and right, and it's a safe way to do the job. And they had that on the site just 2 weeks before the accident happened. They returned it 5 miles away, but they didn't bring it back to do the corrective work.
And they returned it because they didn't want to spend the money, right?
Correct. Even though it was honestly a few $100s.
Yeah, now you brought up a point about you were able to find some workers that were there on the job site at that time that you could talk to. Frankly, you can talk to anybody you want, but people are reluctant to talk, especially if this is going to jeopardize their job with their employer, correct?
First of all, we can't speak to them if they're still employed because they were represented by counsel. But then even if they're not employed, right, they may not want to speak to us. These gentlemen, however, wanted to speak to us.
And how did you find these people?
Various ways. We have a great staff here, and we have great investigators that work for us. And ultimately, we were able to find the last gentleman that saw Kenny. He's living in Florida at the time. I spoke to him on the phone. He had photographs on his phone. He sent his phone up to us. He signed an affidavit for us. That dovetailed into us finding his supervisor, who was more local. He spoke to us. He reconfirmed all of the same facts, meaning that this was corrective work that was being done. He had to be on that ladder. He had no choice but to use that ladder. Right. And then we looked at Kenny's phone, and this was a very smart idea by Andrew Siegel's part. We looked through his phone. We tried to match up any number that looked like it might be local, and we just started calling them. And ultimately, we found 2 of his coworkers that were also no longer employed. We brought them to this office. We were here all day on a Saturday and I think a Sunday too. They looked through all the photographs and they also confirmed the same thing as the other 2 gentlemen from the general contractor.
Which was what?
Which was that Kenny had to be on this ladder, that it was a lie to say that he was directed to only work on the ground level. They had to do this corrective work. The caulk was falling out of the seams of the metal panels that they put up. They had to go up and re-caulk it and then re-wipe it down. And that wiping down action is what Kenny was doing when the ladder started to slip and fall.
Right. So when you were able to prove that, then all of a sudden the contractor, the owner of the building, the contractor becomes responsible for what happened to him, correct?
Correct. A building owner and a contractor or any other agent of the owner that's in a contractual chain with the ultimate employer are all responsible as a matter of law, whether they're there or not.
There is an exception in the New York State labor law, which is what? So that those parties aren't responsible.
The exception is what's called a sole proximate cause defense, meaning that as a matter of law, or a jury could decide it as well if there's a question of fact about some things that happened. If the worker's own action or inaction was the only reason the accident happened, the sole reason, then the general contractor and the owner will not be found liable.
In other words, if he went against their directives, basically, put himself in an unsafe situation.
Not just that, it's more than directives. It's more along the lines of, well, there was a ladder there was a scissor lift there, you chose to use the ladder even though you were told to use the scissor lift. If that was the situation, it would be very different.
This is where your area of expertise comes in, because you are the medical malpractice, you are the medical expert, if you will, in cases like that. But you also had your own take on what happened in this case. What was that?
Yeah, our law office works in mostly a tandem. We're shown as the expert on the labor laws and the protection of construction workers, where I have a higher focus on the medical aspects. In this particular case, we were working in tandem. There was a situation where the defense presented what I would consider a wall of silence. Kenny didn't know what happened or had very little recollection. He had post-traumatic amnesia. We litigated the case. We could only get the information from the witnesses that they presented, not necessarily the ones we wanted to question. Their records indicated Kenny's co-workers, but by first name with no contact numbers. So the two workers that we ultimately contacted, we could not even know of them during the pendency of the lawsuit. And the situation in Kenny's case was that this was the last day on the job, and they had him doing a punch list of items so they could leave the job. As Sean had mentioned earlier, the man lift or the scissor lift, which had been on the property, had been returned. It was rented, and it was rented from a place that was local, less than 5 miles away. On the last day of the job, all they had to do was re-rent this and bring it to the job site, and you and I would not be speaking of the case today.
Yeah, because they were using the scissor lift to do the work that had been done in the improper fashion.
That's correct. And to make things worse in this particular case, at the hospital, Kenny was found to have drug substances within his system. He had methadone and alcohol. So what they also did in terms of a complete defense, the sole proximate cause defense of workers, they tried to state that Kenny was responsible for his own injuries because he had alcohol in his system and evidence of methadone. They actually hired a toxicologist, and we had to combat that as well. We had to hire our own toxicologist to show that there was no level of impairment given the scant amount of alcohol blood content within his bloodstream. And also the one witness they did produce tried to give testimony that when Kenny fell, he was making no motion whatsoever, that he fell stagnantly without motion. And they used that information with their toxicologist to state that, well, he probably passed out before he fell, and that's why he didn't move on his way down. And we had to counter that with our neurologist, who explained the concept of fear and fright. When you're falling from a 25-foot height, you can be frozen, just like being frozen in time. And that was the situation here.
Right. When they make these allegations and accusations, they're forcing trial lawyers to go out and hire their own experts to counter that, right? Because in all of these cases, it becomes the battle of the experts and who the jury believes.
It can be the case, especially on damages in cases like this.
Now, let's talk about the injuries that Kenny suffered.
Well, Kenny fell 25 feet, and he landed on a hard concrete pavement below. And so you have to understand that there's a certain amount of force that's generated when a 175-pound person falls 25 feet. You know, there is a photo of Kenny on the ground, motionless. Understanding the mechanism of injury and traumatic brain injury is one of the most important things, because there is a positive correlation between the amount of force and the residual brain injury. In this case, it wasn't much of an issue because he fell 25 feet. He landed on his head. And the impact was not only an impact of Kenny moving downwards, but you apply Newton's third law of motion. For every action, there's an equal and opposite reaction. That really means for every force, there's an equal and opposite force. So in this situation, when Kenny made contact with the pavement below, you can imagine the tremendous force moving downward, but that was met with an equal and opposite force coming upwards, and that energy has to go somewhere. And in this particular case, it was multiple bone fractures and skull and brain injuries.
Let's talk about Kenny's physical injuries.
Sure. Well, we just discussed the mechanism of injury and the impact. He was unconscious. He gets to the hospital facility, and the first thing you have to do with someone who sustains a high-impact injury to the brain is stabilize them. In his particular case, there was increased intracranial pressure, meaning within the skull, there's a certain amount of normal pressure. The skull is a rigid exoskeleton, for lack of a better term, that houses a brain which is soft. When the pressure inside increases, that pressure exerts force on the brain and herniates or pushes the brain against the side of the skull, and that could be a very dangerous situation. When Kenny was transferred to the hospital to stabilize him, they were concerned with increased pressure within his brain, so they put in actually within the brain, a pressure monitor to monitor the pressure, the intracranial pressure. They also put a tube in his neck, a tracheostomy so he could breathe, and also a feeding tube, just to stabilize him. And he remained at that hospital facility in a very bad state for about 6 weeks until he was transferred to a rehabilitation facility where he spent the next 4 years. And just so you know, Steve, one of our goals in this particular case was to get Kenny home. When you present damages in a case like this, the best evidence, in my opinion, of a brain injured person who's got severe cognitive compromise is to show, don't tell. So I hired a professional videographer who does day-in-the-life videos, which more or less is a compilation between what the injured individual does from the moment they wake up to the moment they go to sleep. And in this particular case, what it showed was incredible. It showed that when Kenny got up in the morning, it was not on his own account. He had to be woken up. He had to be washed by a nurse. He had to be given his medications by a nurse. He had to be dressed by a nurse. He had to be fed by a nurse. And in the day-in-the-life video, one of the things that I think you'll find very compelling is the fact that they gave Kenny his breakfast. It was some porridge, for lack of a better term, and he had silverware right next to him to eat, and you would eat it with a spoon. Kenny looks down. He picks up a straw. He takes the straw out of its wrapping. He folds the straw in half, and he begins using the straw as an instrument to eat his hot cereal until the nurse intervenes and asks him whether or not he would like a spoon. This is the level of injury we're talking about.
Let's talk about the vocational rehab evaluation that he had to go through.
Steve, when someone sustains a traumatic brain injury, and in this case a severe traumatic brain injury, it's incumbent upon the lawyers to ascertain what the nature, level, and degree is of that particular brain injury, and to understand how the brain injury has impacted the individual from a cognitive perspective, how they think, from a behavioral perspective, how they act, and from an emotional perspective, how they feel. And to do that, we had Kenny tested by a highly qualified neuropsychologist who gave him a battery of tests. And what was evident very quickly in Kenny's situation was that he had a significant cognitive impairments.
Let me ask you this question. When you're developing a healthcare plan, right, long-term healthcare plan, do you ever find, or can the other side bring up, that this person might get better? Do they ever offer statistics that said, hey, somebody with a similar type of injury got better, so you don't really need that much money?
It's the old adage, what we prove, what can they disprove, right? In a situation like this, it was very challenging for the defense counsel to disprove pretty much anything on the issue of damages. As I had mentioned, the man had been confined to a rehab facility for 4 years during the pendency of the lawsuit. And his cognitive, emotional, and behavioral functioning was well documented. So that was a big challenge in this particular case.
Let's talk about that life care plan.
Another thing that we do when representing a traumatic brain injury survivor is to ascertain what their future needs will be, both medical and non-medical. And what we do is we hire a highly qualified life care planner to meet with Kenny's significant other, go over the medical records, and formulate a plan that literally lays out all the different things that Kenny will need from this moment in time throughout the course of his life expectancy. And that includes everything from soup to nuts, including modalities of treatment, transportation, care, drugs, physical therapy, if he's going to go home modifications, and things like that. In this particular case, Kenny needed 24/7 supervision.
I've seen many cases, where the other side, the defense, is going to use their own health care plan, right? And they're going to contest the fact he doesn't need that type of service. He can get it from that. How do you deal with that in court? I mean, it's like comparing the gold line service to something that might be just essential.
It's a dangerous thing for defense counsel to do, to have their own life care planner. By doing that, they're kind of embracing the fact that a life care plan may be necessary. So they try to stay away from that. But I have seen it, and what their life care plan does is it minimizes the things that the plaintiff's life care plan does. Sometimes it embraces certain aspects, but the whole goal of that life care planner is to try to minimize. Remember, what happens with the life care plan is then it's given to an economist to project out damages. So the less there is in present day dollars to project out, the less there is in terms of a potential recovery.
Yeah, and you provided us an exhibit that you used, that your economist put together, correct?
Point of the exhibit is to illustrate how, when someone is catastrophically injured, the medical expenses add up. Yeah. And it's necessary for the responsible party to be responsible for those medical expenses as well. In Kenny's case, I believe the life care plan, with its economic factors being plugged in, was over $6 million. It would have been a lot more had he been an old, younger gentleman. Kenny was 57, so for his life expectancy and what was going on here, it wasn't as large as we see in some other cases, although $6 million sounds like a lot.
In Kenny's case, if I remember correctly, he was not married, correct?
That's correct.
He lived with a girlfriend. He cannot take care of his own welfare, basically, or handle the money. So what did you set up for him so that he would be provided for the rest of his life?
Right. So this was a very unusual situation. When we were hired on the case, we were hired by Kenny's girlfriend, who had power of attorney. We weren't there. We never met Kenny when the power of attorney was done. We don't know what his situation was at that point in time. But what we did know is that the client was the girlfriend. But one of my concerns was, since this was going to be a large volume of money, that it be managed professionally. So what I basically did was take the control of the money out of the hands of the girlfriend, put it into a corporate trustee. We also had involved in the case an individual that determines when the money is going to be spent and on what. And in that particular situation, we used a nurse who does that for a living. And as another factor to build, that we built in this trust scenario, is that I requested that an outside individual who works in trust and estates once a year looks over the finances that have been spent on the plan to make sure going forward that money was spent properly.
An audit, in other words, yeah.
Correct.
Have you ever encountered a situation where you had similar facts, but let's say the person who had the power of attorney didn't agree to a trust arrangement? Can you go to court?
I had one situation where I represented a very nice young attorney. It was a horrendous case of malpractice where they herniated and perforated her brain while she was awake. It was a terrible case. When she came out of the hospital, the father put her into a facility in Connecticut, and I went to visit her to make sure things were okay within a few days of her transfer. And when I got there, what I realized was it didn't look like a traditional rehab unit, but rather it looked like a place where you put older people who may need some type of care. I went to the front desk, and in fact, that's what it was. I went outside. I called the father, who was the guardian. I said, we have to get your daughter out of here. And the father said, no, we're not going to get my daughter out of there. It's close to where our home is. It's in Connecticut. And I looked up this place, and it's got great reputation. And I said, yes, it has a great reputation for what it is, but it's not what she needs. So we went back and forth on this phone call, and I ultimately had to say to the guardian, I said, listen, either you allow me to find the proper place for your daughter, or I will have to make a motion to have you removed as her guardian.
Mm-hmm. Was that successful?
What was successful was he listened to me. And then I bartered a deal for her to be transferred to a rehab facility upstate New York. It was $30,000 a month to pay for it. I negotiated a deal with the facility where they would take her for $20,000.
Good. There was a very interesting comment that you made, and I understand that you are a member of the Brain Injury Association of New York State Lawyers, right?
That's correct. It's New York State.
Yeah. And the comment was, when selecting a lawyer to handle a traumatic brain injury, and I'm going to read this so I get this exactly right, in a brain injury case, ask the lawyer, what is the largest sum that the lawyer was advised to take but turned down, and ask what the consequences of that were, or what the results were afterwards. We're showing many of the cases where you were offered nothing, right? And you ended up getting millions of dollars. So talk a little bit about that, because I think that's important, because when folks look for a lawyer that's a competent lawyer, you have to look at not just what the verdicts were or the settlements were, but more importantly, like you brought out, what did they offer that they turned down?
Right. So it's always been my belief the measure of a lawyer is their ability to advise their client not to accept a large sum of money, even if that large sum of money is a sum of money that they would never have ever seen before in their life, if that large sum of money does not fairly compensate them. In Kenny's case, we went to a mediation where they offered $6 million, and we got up at the end of the mediation, we left the room, and the case was not settled. I would venture to say that many attorneys in this scenario, where the defense was that he had alcohol in his system, he had methadone treatment drugs in his system, where there's a pending motion to dismiss, many people would have said, oh, it's a risk, the case can get dismissed, take the $6 million. I didn't think it was fair. Sean didn't think it was fair. So we walked out of the mediation. Several months later, I was contacted by defense counsel, and I said, listen, if you want to do it, why don't you come to my office, and you and I, like professional adversaries, will discuss what we can do here. And that's exactly what happened. And this attorney that was hired on this particular case was one of the experts in defending traumatic brain injury cases. And her and I, we sat down, and the case ultimately resolved for $7.5 million. Now, the difference between 6 million and 7.5, in the big scheme of things, for many people may not seem like a gigantic difference, but when you're talking about a difference of $1 million in Kenny's pocket to pay for future medical care, it's important.
Sean, because of these cases, a lot of people contact you, to handle their case. They want the top lawyers that are going to get the best results, etc. And I'm going to ask each one of you this. How do you select the clients that you eventually represent?
Yeah, we are fortunate in that we are able to look at various clients in various cases and decide for ourselves what we want to get involved in and what we don't want to get involved in. And more times than not, we don't want to get involved in the case for various reasons, and we may think that the case is going to be better handled by another attorney that we know because it's that particular type of case. But the cases that we really want to get involved in are the ones that are challenging, are the ones where the person is so severely injured that we know that if we do what we know we can do, we can change their lives, not just for them, but for their families. And we can give them some sense of justice and some sense of being made whole after such an incredibly unfortunate event.
I have to ask you, though, in this case, there was no way that you could have known that you would have discovered people to substantiate what happened to your client. That was a risk taken there.
It was a great risk. As a matter of fact, there was a motion made by the other side, the defense, to dismiss this case. Sure. And that's what made us go into just another gear where we reinvestigated the entire case, and that's when we ascertained these witnesses. That's when we had the great idea to look through the phone. And within a case that took years to litigate, within a weekend, we completely revolutionized the case. And we always believed in it, because we always believed that this gentleman with 20 years of experience wouldn't just take it upon himself to go up and do very dangerous work unless he had no choice but to do it. We just knew that.
I would guess, Andy, that you would concur with everything he said, correct?
Absolutely, absolutely. Also, Kenny had a severe traumatic brain injury, and that's one of the things that we focus on in this particular law firm. And we understand that those cases come with inherent challenges, such as post-traumatic amnesia and the unavailability of witnesses and a wall of defense by defense counsel, all of which was that particular case, but we overcame it.
Good. Well, congratulations to both of you. I'm sure your client's very pleased. And I want to thank you both for being on the show.
Thank you,
Thank
Steve.
you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.